you so much, everyone. So let's get to the conversation relating to former President Goodluck Jonathan and whether or not he can run for office. Mr. Falana does not believe he can. But we have Mr. Ima Anene from Unsuka. Now, if you can hear me now, Mr. Anene, give us your own perspective to the argument on the former President Goodluck Jonathan.
Good evening and good evening, Nigerians. Thanks for having me. Can you hear me, Sean?
Absolutely.
Hello?
Please go ahead. I can hear you.
Yeah, the assertion by the senior advocate of Nigeria, Femi Falana, is misleading, inaccurate, and untenable in law and in facts. Section 137, subsection 3 of 1999 Constitution provided that anybody, Vice President, is wanting to complete the tenure of a president, and that Vice President is entitled to a single. Whether Section 137, subsection 3 of 1999 Constitution as amended can apply retrospectively or retroactively. If the answer is no, then that supports my assertion that the United Senior Advocate's argument is neither here nor there. It's more or less a political statement than in law. If you look at Section 2, subsection 2B of Interpretation Act, if a particular legislation, a statute, does not have a commencement date, it is taken that the commencement date is from the date it came into effect. Then the issue here is, when does this Section 137, subsection 3 of 1999 Constitution as amended came into effect? It came into effect in 2017 and 2018. That was when it came into effect. Now, President Jonathan left office in 2015. President Jonathan took office to complete the tenure of President Yaradua in May 5th, 2010. So what Femi Falana is saying that you can use this constitutional provision to abrogate the inherent right of President Jonathan. And there are a plethora of decisions. If you look at what happened to Prince Abubakar Audu, Jole Nyame, and Abubakar Abba Ibrahim of Yobe State, they contested the election in 1992, won election. They contested the election in 1999, won election. They contested the election in 2003 as governorship candidates of their respective states in Taraba, Yobe, and Kogi State. Now, that was why Abubakar Audu, the prince, contested the election in the last that brought Yaya Bello into office, because he has been contesting the election before and he won the election. They went to Supreme Court. The Leonard Senior Advocate did not advert his mind to this one. That was when this issue was decided. Rather, he used to bring an issue that does not fall in. Well, the issue he brought has to do with whether, before, if a particular person contests the election and win the election, if the person is sworn in, if peradventure a tribunal nullifies that election, the person will come back recontest again and be sworn in and will continue from the day, judging from the case of the P2B against INEC. But that's no longer the case. The Supreme Court said no, that if you...
But if you look at the spirit and the letters of... sorry, if I may come in quickly. The argument which, of course, there are case laws that the senior advocate put forward yesterday. One major one that he put forward was that of Ladoja versus INEC, where the former governor of Oyo State, who at the time the court has said was unlawfully removed from office, was asking for that he should continue his term, 11-month prayer of 11-month extension to cover the lost time in office. And if you look at the spirit and the letter of the section 1373, that was very specific that you cannot run again if you have come to conclude a term of someone else in office. That is very specific, isn't it? And Constitution as a ground number. Can you give an interpretation that is not captured with it?
Yes, so it's not specific as he put it. That was why I said it's misleading and inaccurate. Supreme Court refused Ladoja's prayer because Ladoja, when he was reinstated in office, paid himself. It would have amounted to absurdity and against the spirit and intent of 1999 Constitution as amended for London having paid himself for 11 months, wherein he did not work, wherein he was outside the government of Oyo State, to come back.
But what about the argument? Sorry, Mr. Nene, what about the argument that the Constitution was specific about 8 years? That you cannot spend more than 8 years. 4 years of not more than 8 years. That's what the Constitution says.
But if the Constitution says it says elected for a period of 4 years. Between May 5th, 2010 to 2011, was Jonathan elected to have served for 4 years? Is that 4 years in the eyes of the law? Is that intendment of the framers of the Constitution? The issue for determination here is what amounts to 4 years.
Please, if you can further your argument and look at what it would have meant should President Goodluck Jonathan get a ticket or get back into the race and becomes president in 2023, or perhaps let's look at his options that is left for him. If there is this kind of confusion as to the possibility of his ambition in 2023, under the law, what are his options? To seek redress or to just go ahead?
You see, I'm not President Jonathan, and I'm not holding brief for President Jonathan. President Jonathan is a man of his own. He knows what to do. But I'm talking as a lawyer, whether there is a constitutional limitation stopping former President Jonathan from running an election in 2023. And I've told you, there is no such thing. If President Jonathan is of the opinion that he wants to contest for the President of the Federal Republic of Nigeria in 2023, he has the right, and that is up to him to take a decision. But as far as the 1999 Constitution as amended is concerned, President Jonathan has no limitation. Now, people are making use and cries, but whether Jonathan coming to contest the election is unprecedented, has never happened, or something like that. Now, who have a case in the United States of America? President Trump is an incumbent.
Mr. Anene, just a moment, so that we can have a multiplicity of opinion on the program on this matter. Mr. Eric Omari is back with us. Mr. Omari, if you can hear me, please go ahead. The question is, with these reactions that this matter has generated, from your own point of view, either legal or political, what is your own perspective?
Well, first and foremost, my view is that Mr. Falana got it wrong to submit that former President Jonathan is not qualified to contest the 2023 election on the basis of Section 137, Subsection 3. The simple reason is that Section 137, Subsection 3 is a product of the fourth alteration of the 1999 Constitution. And the fourth alteration came into effect in June 2000 or July 2018. And at that time, the event that necessitated Jonathan's case coming into the ambit of that provision had occurred. And the law is that you cannot make a law to have retrospective effect. In other words, a law takes effect from the day it comes into operation and not from incidents that have happened in the past. There are plethora of Supreme Court authorities on this position. So Mr. Falana is not correct. And again, he talked about the fact that if Jonathan is allowed to contest for another term, he would at the end of the day spend up to 9 years. That argument is neither here or there. The simple reason is that the Constitution talks of being elected to the office of the President of the Federal Republic of Nigeria for 2 terms. The simple question is, has Jonathan been elected to the office for 2 terms? No. Again, another issue is, are there circumstances under which a person can stay in office beyond 8 years? Yes, there are. Beyond the Jonathan situation, if you look at Section 135, Subsection 3, if the nation, for example, is at war, the president can stay beyond 8 years. So contrary to Falana's argument, there are circumstances under which a president of Nigeria can stay beyond the 8 years term, such as what is provided for under Section 135, Section 3, and situations that the Constitution did not envisage, such as what happened to Goodluck. Because the point you must notice is, Goodluck Jonathan, when he became president upon the demise of Yar'Adua, was not elected to be president of Nigeria. He only completed a term of Yar'Adua. It was only in 2011 that he was elected. So he has been elected only once. So he's still entitled to be elected for 1 final term. And I think that is the position of the law.
So, I mean, the position of the Constitution where it clearly stated 8 years, two terms of 8 years, should former President Jonathan get a nod to become Nigeria's next president in 2023, having spent over 5 years, he would have opportunity of spending another 4 years as provided by the law from 2023. If you add that up, it will amount to over 9 years that he would have been effectively in office. So, in the hour of the interment of that, how the law captioned on that clause, is it ultra the law, or what is your reasoning as the law is being captured in that sense?
So let me create a clear this impression. Mr. Falana, with respect, Lana Senior advocate, yesterday tried to create the impression that under our constitution, under no circumstance can a president stay more than 8 years. Please, there is no such express provision. What happened in the case of Jonathan was a situation that was not envisaged by the constitution. That's number one. Two, when you say a president is to spend 2 terms of 4 years each, amounting to 8 years, that is in an ideal situation, in a situation where all things are equal, in a situation whereby you aspire to be president, you spend your first term, then you aspire again, you spend another term. But this situation, we are confronted with a situation where somebody completed the term of another person, then he contested on his own. So for the purpose of that constitutional provision, which says that you can spend only 2 terms of 8 years, what you should consider is the point from which he started contesting for the office of the president.
Mr. Amare, maybe we should look at the clause 137, subsection 3 again. I think my producer should put it back on screen so that our viewers can see and be able to relate with the argument. It does look like that section was particularly specific. And I read it again. The subsection 3 of 137, which states that a person who was sworn in as president to complete a term for which another person was elected as president shall not be elected to such office for more than a single term. So President Jonathan has been elected in office in 2011 for a single term. So, and that's this section has said shall not be elected for more than a single term. That is that clause. That is the law.
The simple response, Mr. Shehu, is that section 137, subsection 3 does not apply to President Jonathan. The simple reason is that that section, subsection, came into effect in 2008. The law is that we draw a distinction between what we call substantive law and procedural law. The right to contest election form part of substantive law, and the position of law that has been affirmed by the Supreme Court on several occasions is that the substantive law applicable to any situation is a law that was in effect at the point the event occurred. And what is the event here? In 2010 to 2011, Goodluck Jonathan completed the term of Yar'Adua. Then from 2011 to 2015, he served 1 term. That event had occurred before section 137, subsection 3 came into effect. So it is not applicable to him. Section 137, subsection 3 will only be applicable to events that will occur after it came into effect in 2018. That is a simple response to that question, Mr. Shehu.
All right. Okay, thank you so much, Mr. Eric Amare and Mr. Ima Anene. Both of them were been speaking with us virtually. Mr. Anene is in Nsukka and Mr. Amare in Warri. Thank you so much, gentlemen, for talking to us on this matter.
My pleasure.